All right, good afternoon, ladies and gentlemen. We'll go ahead and, you ready? Sorry. Start taking open announcements on the 1:30 dot. Mr. Schmidt. Carissa Rube. All right, it's cause number CR 22-0229-173, the state of Texas versus Carissa Rube, and that is set for pretrial. Any pretrial from the state?
We had previously already filed that with the previous attorney.
Okay. All right, and any on behalf of Ms. Rube?
No, Judge, we don't have any trial at this point. It needs to be heard.
All right, then Ms. Rube, the court deems pretrial is held. Your next court date is November the 9th at 1:30 for status, and that's generally your last day to resolve your case before it ends up on the trial docket. So stay in touch with Mr. Schmidt and your bondsman, and I'll see you back here in November, but wait till you get that reset.
Was that your honor?
1:30.
Thank you.
Mr. Bingham. Good, how you doing?
I was driving down 31 in this black Mercedes with his Texas judge plate shot by. Is that you?
No, I don't have judge plates.
It's just like he pulled in here.
It's Calhoun. He just got here. He walked in a pair of shorts. Yeah, this definitely wasn't me. I drive a white truck with non-star.
I should have done
And it's a beat up pickup truck,
It was just
which is exactly why I don't have judge tags. When I was VA, I'd hear so many Judge Perryman would run people off the road and wait it out. And he'd always call the DA's office. And they'd say, look, Judge, I'm getting the plate. You gotta stop.
Everybody knows, get your car keyed.
Yeah.
That's what Skin said. He's like, "Oh, that's like a target. I'm not doing it."
Yeah. And then they can Google your
He
tag.
looks like he drives by, but
No, we have the same. We all have the same. DoD.
yeah, that's a good one.
I need to tell him to stop doing it. All right, who you got?
I got Marcos Quinones
Okay.
and been working with Mr. Cox on it.
Is he here?
He's around.
Let's call him up. Mr. Kionis. That's funny. I won't tell him who, but I'll say, hey, look.
I'll tell you, I think we got behind him because I was like, I'm getting behind him. Run lead. So
He's an interpreter. All right.
he understood.
And I'll swear the interpreter here in just a moment, whenever you're ready. All right. Solemnly swear you will translate from English to Spanish and Spanish to English to the best of your ability.
I do, Your
All right, I'll call it CR 21-0837-173, the state of Texas versus Marco Quinones, and that is set for status. Mr. Bingham?
Judge, myself and Mr. Cox have been working on the case. I believe the resolution that we're going to have is this case will be dismissed. They're going to file a misdemeanor information to a driver while intoxicated, I guess be a class B, and a felony, criminal mischief, state jail felony. We've agreed on a restitution amount of $12,225, which my client's prepared to pay when he goes on probation. It would be I assume a 2-year deferred on both of them to run obviously concurrently at the same time. We just get a plea date, we'll be back.
You filed some information, but that's our agreement.
So here's the deal, that if you file the class B misdemeanor, we're not going to have jurisdiction over it.
We can come, if it has to go to the court, we have to come back. That makes sense.
And the only way to do it would be to file it as of course, it's not a DWI third. You'd have to file as something else and then plea it down.
Can we just go into that? I'd hate to get into an indictment. I agree that's the only way to do it, but I just hate to do
You'd rather
that.
go into a county court of law.
I would, yeah.
We'll find right around the judge.
Okay. When, how far off do you want to set it?
Whatever's good. I know. Or is it going to be before the new year, do you think, or after?
William? Whatever y'all want. I've got him set for November 9th right now if we have to come back.
November 9th.
I'm in Wood County, have a trial in Wood County.
What are the dates you got, Kevin?
Oh, it's good for y'all. I know in January and February, I'm in Travis County and Kerrville. What's the month? November 8th.
November 8th, what time? Either 9 or 1:30. 9 or 1:30. I should know better than to talk to you. You talk to her. It's kind of like I talked to him.
He's coming in from, you want 9 or 1:30? He drives in from out of town. It'd be easier for,
Right.
if that works.
November 8th, 1:30. Mr. Keonis, make sure you abide by your conditions of bond. Stay in touch with Mr. Mingham and your bondsman, and I'll see you on November 8th.
Judge, thank you.
You're welcome.
Appreciate
See you.
I will see you then.
Mr. Strong.
Thank you, Your Honor.
Yes, ma'am.
It's 9, James Squires.
James Squires. Did you hear all that? All right, it's cause number CR 21-1104-173, the state of Texas versus James Squires, set for discovery status. Mr. Cox, okay,
That's correct, Your Honor. Last time we were here, I was provided with 4 discs. There was an issue with one of them. I've since received a replacement. That disc does work.
okay.
We have received all the discovery.
Right then, Mr. Squires, the court deems discovery status is held. Your next court date is November the 9th at 1:30 for pretrial.
Okay.
And so stay in touch with Mr. Strong and your bondsman, and as soon as you receive your setting, you're free to go. I'll see you back here in November. Wait till you get your setting.
I think that's all.
Yep, that's it.
Awesome. Thanks, Judge.
Mr. Schmidt.
Hey, Your Honor, Jeffrey Lyons, pre-trial.
Jeffrey Lyons. All right, this is cause number CR 21-0672-173, the state of Texas versus Jeffrey Lyons, set for pretrial. Any pretrial from the state?
Judge, I should have court signed our discovery order last month.
That's correct, and I had no objection.
All right, then, Mr. Lyons, and any pretrial?
No, sir.
And will the court then deems pretrial as held, sir? Your next court date is November 9th at 1:30 for status, and that's generally your last day to resolve your case before it ends up on trial.
Yes, sir. I hope we can get it solved.
Me too. So as soon as you get the settings, sir, you're free to go to stay in touch with your bondsman and Mr. Schmidt. I'll see you next month.
All right, thank you.
Welcome.
Same page, Your Honor. Destiny Whited.
Destiny Whited. This is CR 22-0146-173, the state of Texas versus Destiny Whited, set for status.
Yes, Your Honor. We had provided a Brady letter. I believe it just got shared today, but there's a 5-year deferred offer.
Yes, sir. I was just informed there was a Brady letter that was just uploaded, so I would like to see that before we reject or accept anything.
November 9th, 1:30.
Be fine, Your Honor.
Ms. Whited, you're the one being held to bail. You okay with that?
Yes, Your Honor.
All right, I'll see you back here on November 9th at 1:30. You can go as soon as you get that reset notice. Stay in touch with Mr. Schmidt and your bondsman. I'll see you next month.
Page 7, Pete Wood, Your Honor.
Pete Wood. Okay, CR 21-1040-173, the state of Texas versus Pete Wood, set for status.
Yes, Your Honor. State's ready. There was a 20-year offer on paragraph, let's see, on count 2.
Judge, I'm not ready.
Ms. Carpenter and I talked about that there's a list of cases we need to talk about. I was unexpectedly out of town for 10 days, and so if I could have a little more time to visit with her and my client,
November 9th.
be fine. Your Honor.
Mr. Wood, you okay with that? All right, November 9th at 1:30. And so, Mr. Wood, just stay in touch with if your bondsman, if you have any, and as well as your attorney. And as soon as you have your setting, you're free to go. I'll see you next month.
Thank you, Judge.
You're welcome.
Paula Cook, Your Honor, same page. Oh,
Paula
no, I'm
Cook.
sorry, that page 6.
I got you. Paula Cook. This is CR 21-1112-173, the state of Texas versus Paula Cook, set for status, same thing,
Yes,
been
sir.
out of town. All right, do y'all have an offer, or y'all still working on
We're still
one?
working on it.
All right, then, Ms. Cook, I'm gonna let Mr. Schmidt have a little more time. He was out of town unexpectedly. You okay with that? All right, November 9th, 1:30. So stay in touch with your bondsman and Mr. Schmidt, and I'll see you next month.
That's all I have. Your Honor.
Sure.
Thank you.
Need anything, let us know.
Thank you very much.
Mr. Stevens,
Judge, I'm ready on all my cases, whichever order you'd like to.
I like it when you say that, 'cause I can just go down the line. Right. Ralph Brown,
They made me up here.
he was here early because I was in here doing some research. He's here about 1:00 afternoon. CR 22-0089-173, the state of Texas versus Ralph Brown, set for status.
Judge, I think we're gonna, as a fourth place this on the trial docket.
That's correct, Your Honor.
Is there an offer?
Yes, there is, Judge. I think it's 12-month state jail.
Or 4 TDC.
Can I see the indictment? Thank you, man. That's a forklift.
Yes, sir.
That'd be an interesting case. All right, then, Mr. Brown, so it's a 12-month state jail, dropping the 2 enhancements?
Yes.
For 4 years TDC?
Or 4 TDC, yes.
All right, well, Mr. Brown, I know that Mr. Stevens has probably explained this to you in depth, but I'll explain it to you just so we have it on the record. If you, of course, I don't presume you anything other than innocent. I don't know anything about the case, and the law requires that I do. But if you go to trial and you are found guilty, at the punishment stage of that trial, if the state proves these 2 enhancement paragraphs true, not only will either the jury or I hear that evidence, but that would make the punishment range not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice. You understand that?
Yes, sir, I do.
Okay, and so what I'll do is I'm going to actually, would it help if I set it for another status, or y'all locked
Yes.
in?
No, Judge, it would be very helpful.
November 9th at 1:30. I'm gonna let you come back one more time, Mr. Brown. November 9th at 1:30. But if we don't resolve it by then, I'm gonna stick you on the trial docket.
Yes, sir.
All righty, so
You have a blessed day.
you too. So as soon as you get that setting, you're free to go. I'll see you November 9th at 1:30. Stay in touch with AAA bail bonds and your bonds and your attorney.
Yes, sir.
Next is Kaylin Hale. Is Miss Hale, is she the one appearing by Zoom?
Yes, Your Honor, she's by Zoom.
And why are we appearing by Zoom on this one?
She's in rehab in San
Oh,
Antonio.
okay.
She's been there for like 3-4 months now.
All right. Miss Hale, I know you can hear me because you answered. Can you say something?
Yes, sir.
Okay. All right, I'm going to call your case. This is cause number CR 21-1118-173, the state of Texas versus Kaylin Hale, set for status.
Judge, I think in light of the fact that she's in rehab, we're gonna ask for another status.
That's correct, Your Honor. Yes,
All right, Miss Hale, November 9th, 1:30.
Thank you.
All right, so stay in touch with Mr. Stevens. Let him know immediately. Look at that. My internet's unstable. Imagine that. Let him know if something happens in that rehab as well as your bondsman. If not, I'll see you back in November.
Yes, sir.
All right, thank you. You can log off. Network was unstable. Put a man on the moon, but we can't get good internet in the government building. Crystal Smith.
She's up in the hallway, Judge. Do a jury waiver next for a plea date.
Allegedly put a man on the moon. All right, this is cause number CR 22-0147-392. The state of Texas versus Crystal Smith. That is set for status today. However, a waiver of jury has been presented to the court, and now our bandwidth is low. It's kind of stuff I want IT to know. It's ridiculous. Not your fault, Ms. Smith. And so, Ms. Smith or Mr. Stevens, do you mind if I place your client under oath to ask her about the waiver?
Please.
All right, ma'am, if you'll raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? You can lower your hand. Ms. Smith, I know that Mr. Stevens explained this to you, but I'm going to explain it on the record. I'm holding in my hand this document that's titled Waiver of Jury. Do you recognize that document? And did you sign it? And I know that Mr. Stevens explained to you, but I'm going to explain to you on the record that both the United States and Texas constitutions guarantee you a right to trial by jury in this case. You understand that? No one can take that right away from you. Not the federal government, not me, not Mr. Stevens, and not the state. That is your right and your right alone. You understand that? Now, what's the deal y'all have worked out?
Your Honor, it's a 2-year deferred probation on the ag assault with a deadly weapon.
Okay, now, Ms. Smith, if something happens and you get in some trouble or accused of something out there and they pull their deal, or you get cold feet and just decide not to do this, I may not I may not have to let you out of this waiver. Do you understand that? Now, if I didn't let you out of that waiver, you'd still have a right to a trial, but that trial would be in front of a judge, me, and not a jury. Do you understand that? Is this what you want to do? And Mr. Stevens, do you believe your client is entering into this waiver knowingly, intelligently, and voluntarily?
Yes, sir. I believe she is.
Well, the court finds that she has, further finds that the state has consented and is setting this for a plea on November 9th,
That'll work great, Judge.
November 9th, 1:30. All right, so we'll see you then. Stay in touch with your bondsman and Mr. Stevens, and I'll see you for a plea next month. Oh, no, there's Brad right there. I was going to ask if you were handling his cases. I think that does it for you.
Yeah, might be excused.
Yes, sir.
Thank you, Judge.
Mr. Stevens.
Page 8, Michael Moser.
Kind of fast. And then I had that Starbucks at once. Michael Mosier. All right, this is cause number CR 22-0061-173, the state of Texas versus Michael Mosier, and that is set for status.
Can I speak with Mr. Stevens?
Sure. Figure out who's trying to call. Who's Jonathan? Y'all have a Jonathan Hart in the jail? Jonathan Hart, yeah, he just tried to call me. I just want to let you know, I probably can't talk to him. Now they got my cell number.
Judge, I'm going to ask the court to order, I think Mr. Stevens is in agreement with this, but I'm going to ask the court to order Mr. Mosier to take the away.
Okay.
I'm not saying that's going to be dispositive, but it'll go a long way towards a possible resolution.
You all right with that, Mr. Mosier? All right, well then go.
If I may, Judge, if we could go ahead and hold status, I have a hearing across the hall, and if there is an issue, I can come back and we can take up that issue, but I anticipate there's not going to be any issues, but if there are, I can come back after my
You in a
hearing.
motion to suppress?
No, sir, a family law
Oh,
case
family,
and
okay.
Judge Williams court. It's pretty much worked out, but
That's fine. I know he's got some other cases over there as well. All right, well then I'm ordering you to take that test by agreement, Mr. Mosier. So you'll go to probation, take the test. When you get done, come back in the courtroom and we'll get the results and figure out where to go from there. And we'll let you know.
Okay.
Am I resetting this?
Let's reset it for another status, Judge, depending on what happens with this UA, we may have a resolution.
November 9th, 1:30. So come back in anyway, but I'm gonna reset you now for November 9th at 1:30.
Okay. Maybe excuse and I'll.
Yes, sir. We'll let you know. Kimberly Venn. All right, this is cause number CR 21-1102-173, the state of Texas versus Kimberly Venn. And that is set for status. Oh, that's right. She's got the other name. Also cause number, there's Mr. Head, sorry, CR 21-0087-173. This style, the state of Texas versus Kimberly Harris. However, it is the same person. And where are we at?
Your Honor, it's my understanding that the offer is on an open plea, on a reduced offense. We've spoken with Ms. Ben about that. She does not want to accept that today.
So it's going to go on the trial docket, or do we need another status?
Trial docket.
Yes, sir.
I think it's going to need another status. And y'all find out here in a little while. She has a co-defendant, and I'm going to recuse myself on that co-defendant today.
Oh.
And so I'm going to set her for another status. It has nothing to do with the case. It's just my relationship to someone who's related to the co-defendant.
Yes, sir.
And so I'm going to just set it for another status, figure out where that shakes out, and just go from there. So November 9th at 1:30, stay in touch with your attorneys.
I'll be right at Still here.
You got a lot of,
Your Honor, Terry Alato.
Terry Alato. I'll get a call all day and I hit the bench and it rings off the hook. One of them's the jail. All right, this is CR 21-1167-173, the state of Texas versus Terry Alato, and that is set for status first.
Yes, Your Honor, I talked to Mr. Head. There's new information that's exculpatory of Brady regarding the victim. I'm gathering all that information to provide to him, and we need to reconsider our offer.
What about this motion to increase bond? Are we going to hear that today or are we going to wait?
We're not, because it's that victim.
I understand.
Yes, Your Honor.
All right, well then, Mr. Alato, are you okay with resetting this then? Mr. Head?
Yes, sir.
All right, November 9th, 1:30. You'll get that in writing. Stay in touch with Mr. Head and your bondsman, and I'll see you next month. As soon as you get that, you're free to go.
Touch base with me before you start.
You got Newton, Gallegos, Rusty.
Your
whatever you
Honor,
want.
Troy Wymore.
Oh, Troy, okay.
Might be-
Troy Wyman. This is cause number CR 22-0212-173, the state of Texas versus Troy Wymore, set for status.
Judge, I'm gonna fall on my sword here. When we were here last month, I was gonna check with the mother of the victim about a possible resolution of this case. I didn't get a chance to do that. If we could have one more status.
We have no objection, Your Honor.
Mr. Weimer, are you okay?
Yes, sir.
November 9th, 1:30. Stay in touch with Mr. Head, and if you have a bondsman then too, remember any conditions of bond you may have. And I'll see you next month.
Yes, sir. Thank you, Your Honor.
We're up.
All right, David Gallegos.
David Gallegos. Right, cause number CR 18-0436-173, the state of Texas versus David Gallegos, set for status.
Your Honor, this is the first time this case has been set for status. We have a deferred offer. If we could reset this one time just to try to nail down all the terms of the offer, then hopefully we can get this resolved.
Set it for a plea or set it for status?
Your Honor, I think it's safe to set it for a plea. I don't think either side's going to want to trial on a state jail felony.
And I'd hate to set it deferred offer. I'm sure y'all can come to agreement. So I'll set it for a plea on November 9th at 1:30. You all right with that, Mr. Gallegos?
Yes, sir.
All right, so stay in touch with your attorney and your bondsman, and I'll see you back here in November as soon as you have your setting. You're free to go.
Stay in touch. I don't think I've seen Miss Newton yet unless she's outside. She was actually here yesterday. But if we could just reserve on that and on Mr. Russi, and if I could step across the hall, we anticipate having Mr. Russi resolved today.
Snooten, come on up. All right, this is CR 22-0052-173, the state of Texas versus Paige Newton, set for status.
Yes, Your Honor. There was previously, we didn't have an offer, but I did speak with Mr. Head, an offer of 10 years deferred probation.
Your Honor, if we could reset this one additional time so I can go over kind of all the particulars of that with Ms. Newton, as well as provide the state with a little bit of mitigating information that we've obtained recently that might affect the offer a little bit.
November 9th.
Yes, sir.
You all right with that, Miss Newton? You don't have to come to court a day early. You just come on the day you're set. Why we give it to you in writing? But I appreciate you being here early. All right, November 9th at 1:30. Stay in touch with Mr. Head and your bondsman. See you next month.
Let's step outside real quick. And Judge, if I can report back on Mr. Russi shortly.
We're not moving anything, but we're moving. You get your motorhome out of here pretty quick, travel trailer. No, I haven't. I should have, because I went to Starbucks at lunch. Mr. Hunt.
Stephen Davis, John. This is set for status.
Davis, come on up. This is cause number CR 22-0136-173, the state of Texas versus Stephen Davis, set for status.
Discovery, and there has been an offer made for 8 years on both of that, Mr. Lincoln.
And we have what they've sent, and we still have questions about whether it's everything, but that's,
Well, set for status, not discovery status.
I know, and we're in the same place we were back then, but we're just asking this case to be moved to the trial docket, Your Honor.
Judge, can I address that?
Sure.
I believe, well, Mr. Davis, through his attorney, is requesting some documentation regarding the use of force report. However, I've checked with the officers involved. There is no such thing in this case because there was no, the force that they claim was used was not used.
Okay.
So that's an issue.
According to them.
According to them. So that's an issue for cross-examination, but there is nothing else left for the state to give Mr. Hunt.
So it sounds like another status won't do.
I don't think so.
No,
All right.
I would agree.
Mr. Davis, then the court deemed status is held. Your case will go to the trial docket, and we're moving them. And so, Kevin, do you have a reset now? So here's the deal, though, Mr. Davis. Stay in touch Mr. Hunt and your bondsman, because you will receive notice here in a month or so about when to come back. So you're still on bond, and you'll get that notice for when to show up for your trial docket announcement.
Yes, sir.
All right, so stay in touch with them, and I'll see you in a little while.
Yes, sir.
Thank you, Your Honor. That's all the cases I have. May I be excused?
Yep, TCU gonna beat Oklahoma?
I hope so.
Mr. Mills.
Keandre Barlow.
Barlow. Cause number CR 20-0612-173, the state of Texas versus Keandre Barlow. And that is set for status.
Just, Mr. Cox and I've been talking, he did make a 2-year TDC offer yesterday. My client has almost 4 years, I think, of back time, he said. However, this is the one that, he's been in Orange County, charged with a murder case down there.
I thought that was gonna go to trial, and then it got put off.
It went to trial, had a hung jury maybe or something,
Trial had a hung jury. They were going to try and work it out. And they've done it.
unable to. So I feel like we're gonna be able to get this case worked out, but obviously Mr. Barlow doesn't want to plead to an aggravated assault case and get a conviction when he's got a murder case pending down there, because he's afraid they'll use it as punishment, which they obviously would. So whatever court wants to do as far as putting him for trial, but he's not ready to plead today, and I don't know when the murder trial is going. Do you know when it's going to be?
I spoke with the assistant DA in Orange County that's handling that case, and she does not think it'll be tried before the end of this calendar year.
So he's been in Orange County. We've benched him up here a couple of times.
We've left him there a couple times as well. We decided to bring him here this time, hoping we could work it out. But
And you couldn't, as part of the plea bar, you could, as part of the plea bargain, agree not to use it as evidence at any punishment stage of a murder case, but you'd have to get Orange County to agree to that.
I can certainly ask her.
I hate to keep, giving him that diesel therapy of back and forth when I understand the position, I
Right.
certainly do, and it's
He
good
just-
lawyering to do it that way, but if somehow you could work in agreement, I don't know if they would, but
Can I speak with Mr. Mills?
yeah,
I mean, obviously he could go to trial here on this case, but then if he gets convicted, he's going to appeal, so they wouldn't be able to use it against him in the murder trial anyway.
right.
So that's kind of spinning our wheels.
Let's keep him here and have another status, and I'm going to talk to Orange County.
November 9th?
Sure.
Okay. Mr. Barlow, you're the one that's being run back and forth. You all right with that? All right, November 9th at 1:30, and we will not release him back to Orange County until at least till after November 9th.
Still, they're going to keep you from November the 9th. Let's see here. In a minute, Thomas Quintanilla.
Thomas Quintanilla. CR 22-0228-392, the state of Texas versus Thomas Quintanilla, set for status.
Yes, Your Honor, a 10-year TDC offer, including take into consideration another assault family violence previous conviction case.
That's rejected.
Would another status help? Or do I need to put him on the trial?
Honestly, I don't think it would, Judge. In fact, this may be his second status. I thought it
Okay.
might, but I honestly, I don't think it will.
All right, Mr. Quintanilla, I'm not going to give you a setting now. We're going to place your case on the trial docket. Status is held. And stay in touch with your bondsman and your lawyer, and you'll receive notice here in a month or so when to show up for your trial docket status. All right.
Have a plea on Malcolm Smith.
Malcolm Smith. All right, cause number CR 22-0234-392, the state of Texas versus Malcolm Jamal Smith. Set for status today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
On behalf of Mr. Smith,
Ready?
sir, is your name Malcolm Jamal Smith?
Yes, sir.
And are you the same person that was indicted by a Henderson County grand jury in what was originally this second-degree felony offense of aggravated assault with a deadly weapon?
Yes, sir.
I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. Mr. Smith, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, you could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Smith, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Mills, do you believe your client's competent?
He is.
And the court finds that he is. Mr. Smith, I know we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No.
But do you understand the charge?
Yes.
Well, as originally indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. You understand that range?
Yes, sir.
So I guess that's what the original.
Yes, sir.
Right, and the plea bargain?
Yes, Your Honor, in exchange for a plea of guilty, a plea recommendation is 5 years probated with a $500 fine, $1,200 attorney's fees, $355 in court costs, regular conditions of probation, special conditions, $50 to East Texas Crisis Center, $50 to Crime Stoppers, urinalysis testing, obtain a GED within 24 months, 200 hours of community service at 10 hours a month, attend an anger management class, and do not have contact with Karen Rains except through approved CPS or civil papers regarding the children. And that will also take in consideration unindicted 4 times aggravated assault in the same underlying case.
Is that your, well, let me ask you about the complaining witness.
She's been notified and is in agreement, Your Honor.
Okay, is that your understanding of the plea bargain, Mr. Smith?
Yes, sir.
Is that your understanding, Mr. Mills?
Yes.
Well, Mr. Smith, a few minutes ago, you told me you could read and write the English language.
Yes, sir.
I've got 2 documents I'm going to go over with you. The first I'm showing you is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Mills?
All right. Oh, yes, sir. I did.
Did you sign the front and the back?
Yes, sir.
All right, second document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. So read and go over both pages of that document.
Yes, sir.
Did you sign the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Mills?
No, sir.
Well, if you read and went over these with Mr. Mills, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to do this plea bargain?
Yes, sir.
I'll ask you, sir, how do you plead to that second-degree felony offense of aggravated assault? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I hear the evidence.
Your Honor, we offer State's Exhibit 1, the offense report, State's Exhibit 2, discovery compliance.
No objection.
Admitted.
State rests and closes.
With rest and closure.
All right, then, Mr. Smith, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court finds that the complaining witness is in agreement with this, follows the plea bargain, has enough evidence to find you guilty, but follows the plea bargain, considers the 4 unindicted assaults, places you on 5 years community supervision. You do have 6 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and to abide by all the regular and special terms and conditions of community supervision, including the no contact with Karen Rains except through approved CPS or civil documentation. And so, Mr. Smith, have you ever been on probation before?
Yes, sir.
Did you successfully complete it?
Yes, sir.
So you know what it takes.
Yes, sir.
You know what happens if you don't successfully complete this?
Yes, sir.
What happens?
I go to jail
For how long?
2 to 20.
That's right. That's the downside of a deferred. The upside is that you successfully complete it, you don't get the conviction. The downside is if you do violate a term or condition of probation, even one, the state can file a motion, a warrant would be issued for your arrest, you'd be brought back before the court. And if at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 20 years in prison. You understand that?
Yes, sir.
Just at a hearing. You understand that?
Yes,
So
sir.
would you agree with me? It's extremely important you do these things.
Yes, sir.
I hope you do, sir. Good luck to you. You need to see probation.
Demetrius Hardy.
Demetrius Hardy. Cause numbers, or these are cause numbers, CR 22-0144 and 0145-173. Both style, the state of Texas versus Demetrius Hardy, and both set for status.
Commissioner Iyer offers 20 years on the abatement of 40 years.
Mr. Mills,
Judge, he rejects that. He also indicated he wanted to talk to the court.
let me handle status first. All right, so, Mr. Hardy, you want me to place this case on the trial doc? Well, I gotta handle status first. Do you want me to put it on the trial doc?
He actually wants, I think he wants a speedy trial, Judge.
How long has he been in? Well, okay, Mr. Hardy, I'm gonna place you under oath if you're gonna talk to me. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. All right. So you want me to put it on the trial doc? Speedy trial, granted. All right. And so what else did you want to say?
Well, I was wanting to talk to the court today. Last time I was here, brought up a few things. First of all, I want to apologize to you because I got kind of excited last time. So,
That's all right. I understand.
I've been here 11 months now, and you actually helped me understand a few things about a few rules of court, whatever. So I mulled it over and I went back and I looked into the case law and the kiosk we got there to be able to do that. And this article 17-151.
The bail?
Yes, the 90-day deadline thing.
Mhm.
And it was questionable to me at first, but then it was further revealed to me that that's a deadline. And it says that within that deadline, if the defendant has been in jail for I guess for an accusation against him,
Mhm.
and has not gone to trial because the state is not ready within 90 days, must be released from the commencement of detention. That means
Right.
the day I came to jail, 90 days to make answer to the 90-day deadline, taking a trial.
Right.
Okay, I understand that things happen and the docket can be full or whatever, whatnot. Okay, but that burden is on the state.
Mhm, you're right.
The length of the delay has been so far unexplained. I've been here 11 months. When I first came here, the first time I spoke with you, I asked if the court will allow me to initiate by exception a plea of guilty or make with 1244A. I've been here almost 11 months now. I asked the same thing. However, if not, fine. But the fact is that this article has been excessively delayed and it's been violated. I'm not saying maybe it was intentional. Perhaps it was a few mistakes, but mistakes weren't violations if something is set into motion. Does it not?
Well, I understand the way you read the 17-151, but it's well settled law that by the presentment of an indictment, that indicates that the state's ready. So kind of the layman's terms in that is, if an indictment's not presented within 90 days, I got to let you out on a bond or that you can make, or a personal recognizance bond. That's the kind of the way we all kind of think about it. Now, was the state ready for trial within 90 days after the indictment? All right, so were you ready for trial? Okay.
She said she ready for trial. She also said the same thing last time I was here on the 22nd at
Right.
1:30, right here in this courtroom. I demanded trial right then as a right to 32(8.01) trial priorities. I demanded trial.
I don't know what's 32.
0.01 trial priorities, speedy trial.
Oh, 32.0. Is that the one where if you're not
32.8.
tried within? No,
It's 32(8.01) trial priorities.
32.8.01.
32(8).
32A. Let's look at it. I have
Yeah,
kind of a rule in
32A.
here. If you cite a statute that I'm not real familiar with, we pull it out. I think I just looked at this today because I was doing some research and some other things.
Yes, sir.
Believe it or not, I do get into the books.
Yes, sir.
It's Article 32.01, defendant in custody and no indictment presented.
32(8).
Trial priorities.
Trial priorities.
In insofar as is practicable, the trial of a criminal action shall be given preference over trials of civil cases, and the trial of a criminal action against a defendant who is detained in jail pending trial of the action shall be given preference over trials of other criminal actions not described by subsection B. And subsection B deals with victims that are younger than 14 years of age.
That's like this.
Right, that doesn't apply to you.
Right.
Right. And so what's your argument on that one?
My argument was, when I demanded trial as a right to speedy trial, you told me then that you had room to go trial that day on the 22nd.
I don't have a jury.
Right, but she said the state was ready for trial.
Right.
I demanded trial at that time. That's a right. Speedy trial, is it not? Is it not? According to law, it is.
Well, I understand, and that's why lawyers are always a good idea to have, because even though something may say something, there's always an exception. And if you'll look at the code, the statute I just read, as far as practical or practicable, depends on how it's written. So is it practical to have a jury trial every day? Absolutely not. And I told you when you were here the last time,
Yes.
that there are government forces beyond our control that, be careful with my terms here, that government did things that I was not in agreement with,
Okay,
because I believe that it violated everybody's constitutional rights
understand. Understood.
and their right to due process by shutting us down and not letting us to have jury trials from science that was unfounded and that turned out to be not true. However, I was under those orders. I could not summon a jury panel. I could not have trials. But in your case, you were in jail after COVID, right?
Yes, I was.
And is this alleged offense, did it occur after the quote unquote pandemic?
November 17th, 21 is when he was arrested.
Okay.
11 months. That's a delay.
All right. So I've heard you out. What do you want me to do? Just tell me what you want me to do.
Well, what I wanted to say was this, number, and I'm gonna get to my point.
Well, I need you to get to a point pretty quick. I got a whole bunch of people waiting.
Yes, sir. Okay, so when I demanded trial, if you made it clear that there's no way possible you could have got a jury here, right?
Well, I don't know. It was after the pandemic. I'd have to go back and look.
Okay, but would she not be aware of these things as well?
Was you
That
said
you're not
she?
able to get a jury trial?
For the record, you're pointing to the prosecutor.
Yes. And Miss Jenny Holmes?
No.
Assistant DA? Would she not be aware of the knowledge that you just gave to me, Shirley?
Absolutely.
Okay, why did she say she was ready?
She's ready.
Well, why didn't you not demand it? Why didn't you go? Because you said.
Because you don't have a jury.
So it's not ready. The state's not ready.
No, the court's not ready.
Well, of course, not. So how can we go to trial? We can't go to trial, right? So if I've been here.
Again, I think it's, and I understand why you
the
believe
delay,
it's that
the
way,
delay.
but it is absolutely impractical to have a jury trial every day to handle everybody that's in jail. It just doesn't work that way. And I'll tell you that in my experience, someone that's accused of a serious felony as you are, if they go to trial within 1 year, that's pretty good timing. And if you go and look at any other county, I guarantee you're not going to find that they work as fast. There may be some, but very few that work faster than this county does, because we're pretty efficient at what we do. And I understand, hold on, I understand your position and I understand you want a trial. Kevin, where's he at on the trial document? Here's what I'm gonna do, because he's come in here a number of times. I am gonna, where's the one where we may end up in a punishment on an open plea? think that's Mr. Scott's case.
November 14th on that one.
All right, you're going to be the number two. Do we have a number two case on that one?
We do, Your Honor.
What is it?
Esteban Guevara with Steve Green.
Is Mr. Green going to be ready on that?
Judge, it's the one that we spoke to you about, Mr. Green and I having a continuous and moving it to number 2 behind. Mr. Olivas.
What's
Been in
number three?
jail Quite a bit of time.
What's number 3?
Probably Sebastian Martinez. It was a sex case that's set with Mr. Strong, but it never worked out.
Okay.
Mr. Martinez has been in jail less time than Mr. Hardy is, so Mr. Hardy.
All right, well then Mr. Hardy is then put in that place. So that's number 2? Number 3, I'm sorry, it's number 3. So I'm setting you number 3 on,
November what?
He hadn't said it.
November 7th for announcement, 9 o'clock. November 14th for jury.
that okay with you?
I put in motions for speedy trial and everything. It hasn't been answered. Now, had I not asserted my right, then we would be right here. I would stand corrected, but I have. Why is it not getting to you? I don't know, but I have copies right here and right here of everything I wrote, notarized copies in my folder right here. Would you like to examine them?
Not right now. We're at
Because-
status.
So my assertion to the right has been violated. Is what I'm getting at. The burden of proof is divided. The state has the burden of justifying the mental delay. The accused has the burden of proving his assertion to the right and to show with prejudice.
Hold on a second.
That's Cantu 253,
All right,
Southwest Third
look,
at 280.
here's what I'm gonna
It's
do.
case law.
When we set you for trial, if you want to argue all that, I'm doing the best I can with Mr. Hardy. I'm trying to be patient. I want you to be heard, but now you're going down a rabbit hole and I don't know what you're talking about.
I asserted my speedy trial right.
And I
a long
granted
time
it.
ago.
I granted it.
It was asserted a long time ago.
And I granted it a long time ago. But you have people that are in jail longer than you are, and they have the same constitutional rights that you
So
do.
you granted me a speedy trial a long time ago.
I did.
On what day was that?
I don't remember.
Because I have where I put it in right here. That's
Did I
what I'm
grant him a
saying.
speedy trial before?
No.
I think last month, didn't I? All right. Anything else? I granted it. You're the number 3
You
case.
didn't give me a speedy trial, y'all.
I'm going to give you one. It just depends on how speedy it is. I understand your position, but I don't think you understand mine.
You're not hearing me, y'all.
I am hearing you. You're not listening to me. I can't snap my fingers and get a jury in here,
I'm not
Mr.
saying-
Hardy.
I'm not saying that. y'all. I'm saying when I came to jail,
Why would you?
after the indictment, I initiated a speedy trial. That was 7 months ago.
Yeah.
It was not given to me. So the length of delay is unexplained.
Here's what I'm chalking it up to. You have a lack of understanding for the full law. And I understand that. And I don't say that insulting because you're not an attorney. And so you've asserted rights. I've granted your right to a speedy trial. You're set number 3. And we'll see you on November 7th for announcement. Thank you, sir.
That's all I have. Excuse.
Yes, sir. Mr. Scott? Yes, sir.
On page 7, Christopher Burris for plea.
Hey, John.
Yes, sir.
I think the one that I was talking about, you and the state may work that out and go open, but he's gonna want a PSI.
I would, yeah, I would think so, yeah.
So if y'all get it done, let me know quick, because I gotta give them time.
I had to meet with my guy, an interpreter, and the earliest I was able to do that is next, I think, Tuesday or Thursday. So as soon as I know, I'll come.
Yeah, because I need to get a
We'll come
PSI.
with you.
Okay. All right, this is cause number CR 22-0304-173, the state of Texas versus Christopher Burris, set for status. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Burris,
Ready, Your Honor.
sir, is your name Christopher Burris? And are you the same person that was indicted by a Henderson County grand jury for this 3rd-degree felony offense of assault family violence?
Yes.
I'll get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Mr. Burris, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes, sir.
If If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Mr. Burris, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And Mr. Scott, well, do you understand what's going on in here?
Yes, sir.
Well, and you said you had been treated, is that
Yes,
right?
sir.
Have you been diagnosed with anything?
Yes, sir.
What would that be?
Through anxiety, panic, depression, suicidal tendencies.
Are you, or do you have, are you on any medication because of those?
Yes, sir.
And are you taking it as prescribed?
Yes, sir.
Right, and do you understand what's going on in here?
Yes, sir.
And Mr. Scott, do you believe your client is confident?
I do, Your Honor.
And the court finds that he is confident. Mr. Burris, I know we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony, and it carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range?
Yes, sir.
And the plea bargain?
Yes, Your Honor, in exchange for a plea of guilty, the plea recommendation is 2 years in the Texas Department of Criminal Justice System with 104 days time credit, $500 fine, attorney's fees, and court costs.
Is that your understanding of the
Yes,
plea
sir.
bargain?
Yes, sir.
And is that your understanding, Mr. Scott?
Yes, Your Honor.
Well, Mr. Burris, a few minutes ago, you told me you could read and write the English language. I've got 2 documents I'm going to go over with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Scott?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it? Next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign the second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Scott? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to do the plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to the third-degree felony offense of assault family violence? Are you
Guilty.
guilty or not guilty?
Guilty, sir.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, state offers, State's Exhibit 1, the offense report, State's Exhibit 2, the discovery compliance,
No objection, Your Honor.
Admitted.
and the complaining witness is in agreement.
Okay.
State rests and closes.
Defendant rest and close, Your Honor.
All right, then, Mr. Burris, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense, assault, family violence. The court will take judicial notice that the complaining witness is on board and finds that the complaining witness is on board with the plea bargain. Sentences you to 2 years in the Texas Department of Criminal Justice with credit for 164 days. And the court orders you to pay your fine, attorney's fees, and court costs. Mr. Burris, before you go, did you get an,
It was 104 days,
what did I say?
164.
Oh, it looks like a 104 days credit. And so before you go, Mr. Burris, did you get an opportunity to review the judgment?
Yes, sir. I did, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, you're now remanded back or into the custody of the sheriff for transport to TDC to serve out your sentence. Now that you've been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, you need to hire a lawyer. All right, sir, you need to see the bailiff before you have a seat.
That's all I have today. Maybe excuse me.
Yes, sir. Thank you.
Thank you, Judge. And I'll let you know, I think it's Tuesday that I'm meeting with my client.
Yeah, just let us know, because if it's gonna happen, only if it's like.
Yeah, I'm gonna come directly over and talk to Danny. We'll come see you if you're here. Let you know. Thank you.
Mr. Harrington.
Yes, sir. Judge starting off. Page 3, branch from, we can do that in first job.
Martin Brandstrom. All right, this CR 22-0219-173, the state of Texas versus Martin Brandstrom, and that is set for status.
Judge, we've extended an offer of 15-year TBC in addition to we have shared discovery.
That's correct.
All right. And do I need to set it for another status or place it on the trial docket?
Judge, we've been talking about that. Possible, maybe we could have one more status, see if we can resolve it. In contact with Ms. Palmer. If we can work it out, I think we're going to try.
Mr. Branstrom, are you okay with that? And I was going to ask you, state's okay then. So, all right, then, Mr. Branstrom, I'm going to set this for status again on November 9th at 1:30. And so we'll see you then. Yes, sir.
On page 4, Emily Reed.
Emily Reed. CR 20-0363-173, the state of Texas versus Emily Reed, set for status.
Now, we have extended an offer in this case. This is the one where they have an out-of-town attorney that is also with Mr. Harrington. There is a case in Anderson County that I imagine will go first. But we have shared discovery. We have extended an offer, open with the cap.
What's the full offer?
So it would be an open with a cap of 10 years TBC with a lifetime protected order and lifetime registration. However, I understand that Anderson County's offer is different. So depending on what happened in Anderson County, we would be willing to negotiate on that end.
It's my understanding, Your Honor, all that.
Do I have to wait for them?
No, Your Honor, we are set to go to trial. The last I talked to Ms. Mitchell at the beginning of the year.
Oh,
That could
okay.
change, but I believe that they would reach it before anytime that we do.
Understood. We have anything after January we can set it just so we can figure out where we're at? You have any dates? All right, Ms. Reed, I'm going to set you for another status February 2nd at 1:30. Make sure you abide by conditions of bond, stay in touch with your attorneys, and I will see you back here in February. Wait till you get your setting.
No, maybe excuse.
Thank you.
You're on page 2, Jeremy Gilbert, we have a plea and that one.
Jeremy Gilbert. All right, this is CR 21-0614 and CR 21-1059-173. Both styled the state of Texas versus Jeremy Gilbert and both set for status. However, please have been presented to the court in each case with the state ready.
Ready, Your Honor.
Thought you were being excused.
I was, I'm sitting with Mr. Cox.
All right. And on behalf of Mr. Gilbert,
Ready.
sir, is your name Jeremy Matthew Gilbert?
Yes, sir.
And are you the same person that was indicted by a Henderson County grand jury in this 0614 case for the felony offense of possession of a controlled substance?
Yes, sir.
Are you also the same person in this 1059 case that was indicted for the third-degree felony offense of bail jumping?
Yes, sir.
And get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Gilbert, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, we could have certain negative immigration consequences.
Yes, sir.
And Mr. Gilbert, have you ever been treated for any mental health or emotional issues?
Yes, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Harrington, do you believe your client is competent?
Yes, sir.
And the court finds that he is. Mr. Gilbert, I know that we've already arraigned you on each of these cases. However, would you like the district attorney to read the indictments out loud here in the courtroom?
Yes, sir.
Do you understand the charges?
Yes, sir.
Well, this 0614 case, the state jail, the underlying offense is a state jail felony, and it carries a punishment range of not less than 180 days or more than 2 years in state jail and a fine of up to $10,000. Do you understand that range?
Yes, sir.
Can I see the indictment in that one? 0614. When it's got enhancements. However, if you were to go to trial on that case, be found guilty beyond a reasonable doubt at the punishment stage, if the state proved these two alleged enhancement paragraphs true, then the punishment range would be not less than 2 nor more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. You understand that range?
Yes, sir.
In this 1059 case, that is a third-degree felony, and there are no alleged enhancements, so that would carry a punishment range of not less than 2 years or more than 10 years in TDC and a fine of up to $10,000. Do you understand all those different ranges?
Yes, sir.
And the plea bargains?
Your Honor, in 1059, screws and fines, TDC, 300. 0614, 3 years TDC, 200.
Is that your understanding of the plea bargains, Mr. Gilbert?
Yes, sir.
And is that your understanding, Mr. Harrington?
Yes, sir.
Well, Mr. Gilbert, a few minutes ago, you told me you could read and write the English language. Got a couple documents I'm going to go over with you. The first, and I'm showing you one for each case, are the agreed plea recommendations. Did you read and go over both the front and the back of each of those documents with Mr. Harrington?
Yes, sir.
Did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, I'm only showing you one, but there's one for each case. Did you read and go over that document for each case with Mr. Harrington?
Yes, sir.
Did you sign the second page on each of those?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with
No,
Mr.
sir.
Harrington? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial
No, sir.
in either of these
No,
cases?
sir.
Do you want to do both of these plea bargains?
Yes, sir.
Then I'll ask you, sir, in cause number CR 21-1059-173 to the third-degree felony offense of bail jumping, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
And in cause number CR 21-0614-173 to that felony offense of possession of a controlled substance, are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are for no other reason?
Yes, sir.
And sir, your answers to my next questions will be true or not true. Is it true or not true that in 2001 in Dallas County, you were convicted of the felony offense of robbery?
Yes, sir.
Is it true or
Yes,
not
sir.
true? And are you pleading true because it is and for no other reason?
Yes, sir.
Is it true or not true that in 2011, you were convicted of the felony offense of evading arrest? True or not true?
True.
And that was in Kaufman County.
Yes, sir.
All right. And are you pleading true to that because it is true and for no other reason?
Yes, sir.
I'll hear the evidence in each case.
Judge, in 1059, I have page 1, bond paperwork and certificate of call.
Objection.
Admitted.
Rest in that cause, and then the other cause number at states 1 offense report, states 2, 3914 compliance, and states 3 is a lab.
Objection.
Admitted.
State rest in that cause as well.
Please rest in both cases.
All right, then, Mr. Gilbert, in cause number CR 21-1059-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of bail jumping. The court will follow the plea bargain, sentences you to 3 years in the Texas Department of Criminal Justice. You do have 227 days credit. And the court orders you to pay your court costs. In this case, will run concurrently with CR 21-0614-173. And in that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that possession of a controlled substance. Based upon your pleas of true and the evidence, the court has enough evidence to find the 2 enhancement paragraphs true and does find them true. The court will follow the plea bargain, sentences you to 3 years in the Texas Department of Criminal Justice with credit for 228 days and orders you to pay your attorney's fees, court costs, and lab fee. And before you go, Mr. Gilbert, did you get an opportunity to review the judgments in each of your cases?
Sir.
Each of those was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, you're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you, Mr. Gilbert. You need to see the bailiff. You're right.
Tyler Russell, same thing.
Tyler Russell. All right, this is cause number CR 21-1012-173, the state of Texas versus Tyler Russell. And that is set for a plea today, and a plea has been presented to the court. Is the state ready?
Ready, Your Honor.
And on behalf of Mr. Russell,
Ready.
sir, is your name Tyler Devontae Russell?
Yes, sir.
And are you the same person that was indicted by a Henderson County grand jury for this third-degree felony offense of evading arrest?
Yes, sir.
Would you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And lower your hand. Mr. Russell, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Russell, have you ever been treated for any mental health or emotional issues?
Yes, sir.
You understand what's going on in here?
Yes, sir.
Mr. Harrington, do you believe your client is competent?
Yes, sir.
And the court finds that he is. Mr. Russell, I know we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
Do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony, and it carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000.
Yes, sir.
You understand the range?
Yes, sir.
In the plea bargain?
Your Honor, we're asking the court to defer a finding of guilt in place to defendant on probation for 2 years. Fine, attorney fees, court costs, and all standard terms and conditions of probation.
Is that your understanding of the plea bargain, Mr. Russell?
Yes, sir.
Is that your understanding, Mr. Harrington?
Yes, sir.
Mr. Russell, a few minutes ago, you told me you could read and write the English language. I've got 2 documents I'm showing you that I'm going to go over with you.
Yes, sir.
The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Harrington?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign the second page?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Harrington?
Yes, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes, sir.
You want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that third-degree felony offense of evading arrest or detention? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Judge, states 1, the offense report, states 2, 3914 compliance,
No objection.
Admitted.
state rests.
Rest.
All right, then, Mr. Russell, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, places you on 2 years of community supervision. You do have 1 day credit as to any sentence you may eventually have to serve. And the court orders you to pay your fine, attorney's fees, and court costs, as well as abiding by all the regular and special terms and conditions of community supervision. And Mr. Russell, have you ever been on probation before?
Yes, sir.
Where there are a lot of things you have to do and a few things you can't do in there. You understand that?
Yes, sir.
And you know what can happen if you violate any term or condition?
Yes, sir.
What can happen?
We retired in the sentence of 10 years.
That's correct. Here's what can happen. If you violate even one term or condition of this probation, a motion could be filed. A warrant would be issued for your arrest. You'd be brought back before the court. And if at a hearing, the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison with just a hearing. You understand that? So would you agree with me? It's extremely important you do these.
Yes, sir.
I hope you do, sir. Good luck to you. You need to see probation. My phone is going crazy.
Bradley Winkles.
All right, let's do this. I'm gonna take about a 5-minute recess. I need to see the attorneys in chambers. And if I can see them in chambers. Take about 5.
Oh, yeah, that's what I was doing. Thank you.
All rise. Gonna be seated. Thank you. Mr. Head, Mr. Harrington.
No,
Mr.
it's
Head.
just a play on Mr. Rusty.
Okay.
Rusty. Oh, yeah.
Doing, Mr. Russell? Doing pretty good. Oh, he's got them. I was gonna say, I think I'm missing a few here. I'm just saying, let's get some paperwork.
I got everything.
What are we doing with the, I guess we're abandoning the enhancement paragraph? Enhancement paragraph makes it a 15 to 99.
Yes, Judge, you are.
Did you have a motion in there?
I believe there's one in there.
Okay. If not, you got a motion to dismiss one case, but I don't see a motion to abandon the other. You can follow up with it. All right, this is cause numbers, or these are cause numbers. CR 21-0777 173 and cause number CR 21-0956 392. Both styled the state of Texas versus Patrick Russey. Each set for a plea today. However, a plea has been presented on the 777 case, which would resolve both cases. Is the state ready? On behalf of Mr. Russey.
We're ready, Your Honor.
Sir, is your name Patrick Lewis Russey? Yes. Are you the same person that was indicted by Henderson County Grand Jury for this first-degree felony offense of manufacture, delivery of a controlled substance? Yes. You get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Lower your hand. Mr. Russey, can you read and write the English language? Yes, sir. Are you a U.S. citizen? Yes, sir. If it turns out you're not, and you enter into this plea bargain with the state, it has certain negative immigration consequences. Do you understand that? Yes, sir. Mr. Russey, have you ever been treated for any mental health or emotional issues? No, sir. Do you understand what's going on in here? Yes, sir. Mr. Head, you believe your client is competent?
I do, Your Honor.
The court finds that he is. Mr. Russey, I know we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? No. But do you understand the charge? Yes. Well, as indicted, that charge is a first-degree felony, which carries a punishment range of not less than 5 years nor more than 99 years or life in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that, right? Yes. However, state's alleged enhancement paragraph, and if you were to go to trial on this case, be found guilty beyond a reasonable doubt, that punishment, if the state proved that enhancement paragraph true, the punishment range would be 15 years to 99 years or life and a fine of up to $10,000. You understand that range? In the plea bargain?
Your Honor, 7 years confinement, C, 423 days served.
I got 443.
That's correct. I just can't do that.
It's okay. Is that your understanding of the plea bargain, Mr. Russey? Yes, sir. Is that your understanding, Mr. Head?
Yes, sir, Your Honor.
Well, Mr. Russey, a few minutes ago, you told me you could read and write the English language. I've got 2 documents I'm showing you here. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document, Mr. Head? I did. And did you sign the front and the back? Yes, sir. Do you have any questions about it? No, sir. The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? I did. Did you sign the second page? Yes, sir. Do you have any questions about it? No, sir. Do you have any questions about any of the documents that you read and went over with Mr. Head? No, sir. you read one over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. You want a jury trial.
No, sir.
You want to do the plea bargain.
Yes, sir.
And then I'll ask you, sir, how do you plead to that first degree felony offense of manufacture delivery of a controlled substance?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Judge, I had state foreign offense report, stage 2, 3914 compliance, stage 3 is the lab.
No objection, Your Honor.
Admitted.
You rest.
Your Honor, we'd rest and close. We're just executing the motion to abandon the enhancement.
This is a motion to consider, not abandon.
I think we already did that.
You already
one,
did that
actually.
one.
I think that one's already in the file.
Well, hold on a second. It might not. I see that. Yeah, you did it. You can make a oral motion, doesn't matter.
I'll just move to abandon the enhancement paragraph.
Granted, in light of the plea bargain. So anything else?
No, sir. Your Honor.
All right, then, Mr. Russi, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that first degree felony offense of manufactured delivery of a controlled substance. The court, having granted the state's motion to abandon the enhancement paragraph, follows the plea bargain, considers the 0956 case and the unindicted case on the plea sheet and sentences you to 7 years in the Texas Department of Criminal Justice with credit for 443 days. And the court orders you to pay your court costs and lab fee. Before you go, Mr. Russi, did you get an opportunity to review the judgment in your case?
I do.
Was your name, the charge, and the time credit correct?
Yes.
All right, sir, you're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you,
Ready.
sir. Need to see the bailiff.
Just do my best.
Yes, sir, please. What is that reading? Mr. Winkles? Have we seen Mr. Weiner? Yes, sir.
We can ask his partner.
Mr. Head, is Mr. Weiner going to be here from Miss Cirillo? Do you know?
Judge, I am standing in for Mr. Weiner.
Okay, Mr. Harrington.
Yes, sir. Mr. Lincoln. It's page 5, I believe.
I got you. Right, this cause number CR 21-1103-173, the state of Texas versus Bradley Winkles, set forth status.
Your Honor, I believe in this case, I've been talking to Mr. Cox about possible resolution, and I think we request we get another status conference. We keep working on that. There's some other outstanding issues.
That's correct, Judge.
November 9th.
Yes, sir.
All right, Mr. Winkles, you're subject to be drug tested anytime you come in here, November 9th at 1:30. Stay in touch with Mr. Harrington and your bondsman. I'll see you back in November.
Yes, sir. Thank you, Judge. Maybe it's.
Yes, sir. Appreciate it. Mr. Tankersley. Hey, how are you? All right, this is cause number CR 22-0045-392, the state of Texas versus Austin Cox, and that is set for status today. However, a plea has been presented to the court. Is the state ready?
State's ready, Your Honor.
And on behalf of Mr. Cox?
Yes, Your Honor.
All right, sir, is your name Austin William Cox? Are you the same person that was indicted by a Henderson County grand jury in this second degree felony offense of aggravated assault with a deadly weapon?
Yes.
I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. All right, lower your hand. Can you do me a favor? Take a deep breath. You a little nervous? You don't have to be, okay? Got it? All right, here we go. Mr. Cox, can you read and write the English language? Are you a U.S. citizen? It turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. You understand that? And Mr. Cox, have you ever been treated for any mental health or emotional issues? Okay, are you on any kind of treatment for that or counseling?
I've had counseling.
Okay, all right, but do you understand what's going on in here? And Mr. Tankersley, do you believe your client is competent?
I do, Your Honor.
All right, well, Mr. Cox, even though you've told me you've had this diagnosis, you've been in my courtroom a number of times. Based upon your demeanor, your answers to my questions, and your statements of counsel, the law presumes you competent, and I find no other reason to find that you're not, or any reason to find you're not, so I'm gonna find you are competent. Now, Mr. Cox, I know we've already arraigned you on this case, but would you like the prosecutor to read the indictment out loud here in the courtroom? Do you understand the charge? Okay. Well, as indicted, that charge is a second-degree felony, and it carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range of punishment? In the plea bargain?
Yes, Your Honor, in exchange for plea guilty, plea recommendations to defer imputation of guilt, place him on 5 years probation with 3 days of time credit, $1,000 fine, court costs to take in consideration the misdemeanor, the deadly conduct, terrorist threat, and regular and special conditions of probation.
That's our understanding. Your Honor.
Was that your understanding, Mr. Cox? All right. Mr. Cox, a few minutes ago, you told me you could read and write the English language. I've got 2 documents I'm going to go over with you. First is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Mr. Tankersley?
Yes.
And did you sign the front and the back?
Yes.
Do you have any questions about it? Next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? Did you sign the second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Tankersley? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. You want a jury trial? You want to do a jury trial or you want to do this plea bargain? The plea bargain? You want to do the plea bargain? All right. Well, then I'll ask you, Mr. Cox, how do you plead to that second-degree felony offense of aggravated assault? Are you guilty or not guilty? And are you pleading guilty because you are and for no other reason? I'll hear the evidence.
Your Honor, we also stated that 1 offense report, 6 exhibit 2 discovery components.
No objections.
Admitted it.
State rests and closes.
The defense rests and closes, Your Honor.
All right, then, Mr. Cox, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, considers that misdemeanor on the plea sheet and punishing you, places you on 5 years of community supervision. You do have 3 days of credit as to any sentence you may eventually have to serve, and orders you to pay your fine, court costs, and abide by all the regular and special terms and conditions of community supervision. And Mr. Cox, you've never been in any trouble before, have you? So you've never been on probation before, have you? Well, there are a lot of things you have to do and a few things you can't do while on probation. You understand that? And you know what can happen to you if you violate your probation. Go to jail for how long?
Up to 20 years.
That's right. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if at a hearing, the court found it true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 20 years in prison. You understand that? And I didn't ask, the complaining witness is on board?
Yes, she did an affidavit of non-cause.
Okay. And the court finds she is. And so you understand that, Mr. Cox? Well, I hope you do, sir. Good luck to you. You need to see probation before you leave.
Thank you, Your Honor.
Sir, good to see you, Mr. Tinker. Mr. Head.
Yes, sir, Your Honor. Good thing again for Mr. White.
Ms. Cirillo.
Thank you for reminding me.
Well, it was, I was just kind of going through and see what was left. I was like, where's Mr. Weiner? I haven't seen him. Good morning, or good afternoon. This is CR 20-0548-173, the state of Texas versus Yasica Cirillo, set for status. And on behalf of Mr. Weiner, Mr. Head is standing in. Where are we at?
Judge, I spoke with Mr. Weiner earlier this week or late last week. I think we're going to, I think we have an agreement which will involve the payment of some restitution.
Reset it.
Maybe we could give it to December.
I think Mr. Meyer was asking somewhere between 60 and 90 days, because it's a fairly significant amount of restitution that I think you're talking about.
Did we set anything else in January? February 2nd. That's November, December. That's 90 days. I'm just gonna set it, what time did we do that one? I wrote it down. I didn't write the time down either. Was that Mr. Bingham's client?
No, that was Mr. Harrington.
Oh, that's right. Danny, do you remember? 1:30, February 2nd at 1:30. Okay, so as soon as you receive that setting, you're free to go, and we'll see you in February. That's really funny, Melanie. You take good notes. Melanie takes good notes.
Your Honor, may I be
Yes, sir.
excused now?
Mr. Stevens.
Your Honor, Michael Moser, set for drug test.
All right, back on the record and cause number CR 22-0061-173, the state of Texas versus Michael Mosier. And we didn't have status yet. Well, we kind of got, we did, and we reset it.
We did reset.
All right, well, I do have a drug test back. It shows positive for meth, but not amphetamine. So what do we want to do?
In your honor, I can list some testimony if need be. He had a steroid shot yesterday, and he also takes a medication called bupropion. Just some early research shows those can lead to false positive. He's willing to go pay to get the drug test done at the lab, because we kind of had something worked out that if he was negative, there's a chance that a certain offer was going to be made.
Understood.
So he wants to go take that test at the lab today. So we're
It's-
asking.
It's up to him if he wants to do it. I mean, I'm not gonna put him in jail because I would have set this one off for confirmation anyway.
And I think my client wants to do that to prove so that.
People tell,
No, I know,
I'm not saying I disagree with you, but people tell me that all the time and then they hit for the cycle.
Judge, just to let you know, they did not monitor the UAs at the lab though.
I don't know what, oh, they don't monitor, you don't have like
No,
someone
they go
watching
in
them go?
behind- No, they don't watch them. No, the test nails, of course, but not.
I don't know, y'all, I'm just gonna reset it for November 9th. Y'all do what you want to do.
Yes, sir.
Because I mean, if it affects the offer, it's up to the state on whether they want to do it. So I'm not gonna order it either way. All right, Mr. Mosier, I'll see you in November. We'll see what happens.
All right, thank you, Judge.
Who am I missing? Is that everybody? Oh, man. You know, the thing, I don't mind letting people have their day in court. But he's right. He needs a trial, but hey, yeah, I know. You know, you feel bad for him because it's like he's reading, he's so sure his position, but he's wrong.
Mr. Is it Barlow?
I don't know.